All right, welcome back to the deep dive. Today we're going to be tackling a situation that hopefully none of our listeners ever have to actually deal with. But just in case, let's talk about it.
Yeah, and I hope this is just something that's purely theoretical for folks. But you got to be prepared just in case this ever happens.
So today we're talking about what happens if a government contract you're working on gets terminated.
Right, and specifically termination for convenience. Right, not a
Right.
situation where you've defaulted or something's gone wrong on your end. This is the government saying, you know what, we don't need this anymore.
Yeah, they just pulled the plug. So to guide us on this journey, we have this great piece from Holland and Knight's government contracts blog, and they point out that this sort of thing might even become more common.
Right, and they highlight some of the reasons behind that. Things like changing agency priorities, maybe work is deemed no longer essential, stuff like that. And they connect this to some recent executive actions and public statements that suggest this trend.
All right, so it's a good time to brush up on this stuff. And, the thing is, this isn't just about understanding why it happens. The big question is, what do you do if you're on the receiving end of one of these terminations?
Exactly. And that's where this deep dive comes in. We want to equip our listeners with exactly. It's like understanding the lay of the land before you make any moves.
Right, crucial first step. So you've got the notice, you've read it carefully, what's next?
Well, before you sign anything, before you do anything rash, the article is very clear. Get a lawyer.
Yeah, that's usually good advice when dealing with legal stuff.
Especially here. Get some legal counsel involved right away because they can guide you through the process, make sure your rights are protected.
Okay, so lawyer up. Makes sense. What about internally? What do you need to do within your own company right off the bat?
The article's pretty clear on this one, too. Stop all work related to the contract immediately. And that doesn't just mean your in-house staff.
Right, you probably have subcontractors, other people working on this project.
Exactly. You need to issue stop work orders to all your subcontractors and consultants. Everything grinds to a halt.
And I imagine that gets pretty complicated when you're talking about all those other companies and individuals.
Yeah, the ripple effect can be huge. And that's why the article emphasizes you've got to be really careful about how this termination impacts your subs. You need to make sure you're complying with any notice and settlement provisions that are in your agreements with them.
So you need to know what you owe them, how much notice you have to give them, that sort of thing.
Exactly. And another piece of advice that the article mentions, and I think this is really smart, proactive communication is key.
Meaning,
Reach out to those subcontractors as soon as possible, explain the situation, keep them in the loop. That can really help to avoid disputes and make the whole process smoother.
so it's about managing that whole chain of responsibility, not just cutting people off.
Right, communication is key. And while you're doing all of this, the article mentions deadlines, right? Those are super important.
Yeah, I noticed that too. Like deadlines for what exactly?
Well, the termination notice might have a specific time frame for you to submit your settlement proposal. That's basically your claim for all the costs you want to recover from the government.
Right, so you're putting together a package that says, hey, this is what we spent, this is what we lost.
Exactly. And if you miss those deadlines, it can really hurt your chances of getting paid what you're owed. So pay close attention to those dates and don't let them slip by.
Got it. Deadlines are serious business. So we've got the lawyer, we've stopped work, we've notified everyone, and we've marked those deadlines. What's next?
Be the next.
Now we have to dig into the contract itself, right?
Absolutely. And here's where it gets a little technical, but bear with me. The next crucial step is to find and really carefully review the specific termination for convenience clause in your government contract. That's where the nitty-gritty details are going to be.
So basically we're looking for the fine print that lays out how this whole termination thing is supposed to work.
Exactly. And the article points out that your rights as a contractor are directly tied to the specific type of contract you have and the relevant FAR clause that's in it.
FARB.
FAR, the Federal Acquisition Regulation, it's basically the rule book for government contracting. And there are different off-R clauses for different types of contracts, so you got to know which one applies to your situation.
So it's not a one-size-fits-all.
Not at all. That FR clause is going to tell you exactly what you need to do after getting the termination notice, like how to officially stop work, how to terminate those subcontracts, and what you need to include in your settlement proposal.
So you're saying we need to become FIR experts.
Well, at least familiar with the parts that are relevant to your situation. And actually, there's one specific FIR regulation the article highlights that's worth knowing about.
Okay, give it to me.
It's FIR 49.104. That one spells out the responsibilities of both the government and the contractor once a termination for convenience happens. So that's definitely worth checking out.
All right, so FIR 49.104 noted. We've got our internal house in order. We're getting familiar with the legalese. Now let's talk about the part that everyone's really concerned about, getting paid.
Yeah, that's the bottom line, right? But here's the thing, and the article really emphasizes this. The burden of proof is on you.
Meaning?
You have to be able to prove every single dollar you're claiming in your settlement proposal. The government's not just going to take your word for it.
So we're talking about receipts, invoices, timesheets, the whole 9 yards.
Exactly. You need solid documentation to back up every cost you're trying to recover. The more organized and thorough you are, the better. And there's another FR clause that's relevant here.
Oh, another one to add to our list.
This one is FAR 49.206-2. It specifically deals with documentation requirements for these settlement proposals. So that's your go-to resource for making sure you've got all your ducks in a row.
Okay, so we're talking about a potentially huge amount of paperwork here.
Yeah.
Any tips on how to manage that?
Yeah, actually, the article has a really practical tip. Set up separate internal codes, like timekeeping and cost codes, specifically for the people who are working on the settlement proposal itself.
Ah, so you can track exactly how much it costs to put the proposal together.
Right, because that's a cost you can recover too. It falls under the category of reasonable costs of settlement.
Smart. So you're basically building an audit trail right from the start. Now, the article also mentions a scenario where there might be a stop work order before the actual termination notice comes through. How does that change things?
Good point. That definitely happens sometimes. And in those cases, you've got to be really diligent about documenting why you needed to keep things ready to go during that stop work period.
So you might have people on standby, equipment sitting idle, that sort of thing.
Right. And you need to be able to explain why you couldn't just reassign those resources to other projects, why it was necessary to maintain that state of readiness just in case the project got back on track. And of course, you also need to document all the efforts you made to minimize costs during the stop work period.
So it's all about showing that you were acting responsibly, even in a period of uncertainty. Okay, so you've meticulously documented everything. You've got this mountain of paperwork. What kinds of costs can you realistically expect to get back after a termination for convenience?
All right, this is where it gets a little into the weeds, but it's important to understand. For most government contracts, those that are considered non-commercial and not under the FAR Part 12, a termination for convenience basically switches the payment model for the terminated portion to a cost reimbursement basis.
So instead of getting paid a fixed price for the work, you're now getting reimbursed for your actual costs.
Exactly. And then those allowable costs are determined under FR Part 31, which basically outlines the rules for what the government will and won't reimburse.
Okay, so what are some of the specific categories of costs that you can typically recover?
The article breaks it down into a few key areas. First, you can get paid for the work you actually performed up until the termination notice. That's pretty straightforward.
Right, you did the work, you get paid.
Then there's reasonable profit. But keep in mind, this usually applies only to the completed work, not to any parts of the contract that you didn't get to finish.
So no profit on work that never happened. Makes sense. What else?
You can also recover those reasonable costs of settlement we talked about earlier. Those are the costs of putting your proposal together, getting legal help, all of that.
And those are in addition to the actual costs of the project itself.
Exactly. And then there are wind down costs. These are the costs that come directly from having to shut down operations, things like demobilizing equipment, maybe severance pay for employees who are laid off because of the termination, and the cost of terminating your own subcontracts.
So it's kind of a multi-pronged approach. Get paid for what you did, get some profit on that, and then get reimbursed for all the extra costs that come with unwinding everything.
Exactly. Now, the article also points out that things work a bit differently for commercial contracts, those that fall under FRR Part 12.
Okay, so there's a separate set of rules for those.
Right. For commercial contracts, FAR 52.212-4 outlines a couple of different ways you might be compensated. One option is to get paid a percentage of the overall contract price based on how much work you completed, plus what are called reasonable termination charges.
And what are those?
They're basically any costs you incurred that were unavoidable due to the termination. The key is that they have to be reasonable.
So you have to be able to justify them, show that they were directly related to the termination.
Right. And the good news is that under this option, you don't have to follow the government's really strict cost accounting standards.
So potentially less paperwork and hassle.
Yeah, it can be a bit simpler, and the government doesn't have the same audit rights either.
Interesting. So what's the other option for commercial contracts?
The other way is to get paid based on the actual direct labor hours you spend on the project, plus those same reasonable termination charges. Again, you can use your standard business records to justify those charges. You don't have to go through the whole FAR Part 31 cost accounting rigmarole.
So it sounds like for commercial contracts, there's more emphasis on your regular business practices for documenting costs, as long as you can show those costs were legitimately tied to the termination.
Right. And that's spelled out in FAR 52.212-4, alternate 1, if anyone wants to look it up.
All right, so we've got all our ducks in a row. We know what costs we can claim. Now the big moment, submitting the settlement proposal. What's the key advice here?
The article really stresses this. Don't miss the deadlines. And remember, the termination notice might give you a shorter deadline than the standard 1 year allowed under the FAR.
Right, they might try to squeeze you on that.
Exactly. So pay close attention to the specific date in your notice and get that proposal in on time. Because if you miss the deadline, the contracting officer can basically decide how much to pay you, and that's usually not going to be in your favor.
So it's worth checking in with your lawyer on that timeline just to make sure you're good.
Absolutely. And also remember that putting together a really strong, well-supported proposal takes time and effort. Don't try to rush it at the last minute.
Yeah, this isn't something you could just slap together overnight.
Definitely not. And one last thing, and I think this is really important. Keep the lines of communication open with the contracting officer at the agency.
So don't just submit the proposal and disappear.
Right. Keep them in the loop. Let them know how things are going. Ask them questions if something's unclear. That kind of open dialogue can help things move smoother and hopefully avoid disputes down the line.
So it's almost like you're trying to maintain a collaborative relationship, even though this is a termination.
In a way, yeah. It's about working together to get to a fair resolution.
Makes sense. Okay, let's do a quick recap of those key takeaways from the Holland and Knight article. What are the most crucial things for a contractor to remember if they're facing a termination for convenience?
First and foremost, get a lawyer involved early. They can be invaluable throughout the process. And remember, those legal fees are recoverable.
So don't skip on that part. What else?
Second, send out those termination notices to your subs as soon as possible. Get that chain reaction going in a timely manner.
And third?
Third, documentation is king. Make sure your settlement proposal is airtight with all the supporting evidence you can muster. And setting up those separate tracking codes from the very beginning can be a lifesaver.
Right, because if you can't prove it, you can't claim it.
Exactly. And although this article was written in 2025, in our little hypothetical world, the message about staying informed is really timeless, isn't it?
Yeah, things are always changing, especially in government.
Right. You've always got to be on top of any new policies, executive orders, any shifts in agency priorities that could impact how these terminations are handled and how negotiations play out. Stay connected with your industry associations, talk to your lawyers, that kind of thing.
So basically, never stop learning and adapting.
Exactly.
All right, well, that was a lot of information. But hopefully it's helpful for anyone out there who might find themselves in this situation.
Right. And the key message is this. While a termination for convenience can be a huge disruption, knowing the process, knowing your rights, and taking the right steps can make a big difference.
So act quickly, document everything, get expert help, and don't panic.
Exactly. And you know, it makes me think about something. Given that these terminations might become more common, it's worth asking ourselves, what can businesses in the government contracting world do to make themselves more resilient? What kind of strategies can they put in place to minimize the impact of these kinds of disruptions, regardless of what's happening in the political landscape?
Yeah, it's almost like you need to have a contingency plan in place from the get-go.
Exactly. Something to think about for sure.
Well, that's all the time we have for today. Thanks for listening, and we'll see you next time on The Deep Dive.